Start. Facts pleaded to establish the titlement of the plaintiff as a right of the land were controverted in the written statement filed on behalf of the defendants. Stop. Since ultimately, according to the decision which I am going to give, the plaint has to be rejected as having been filed without compliance with the mandatory provisions of law contained in Section 80 of the Code, it has not been necessary either to state the details of the facts of the plaintiff's case or to recite the facts controverting it. Stop. In regard to the question of Section 80, notice, however, it was pleaded in paragraph 3 of the written statement that the suit is not maintainable for want of notice under Section 80 of the Code. Stop. In paragraph 14, it was stated that the statement in paragraph 20 of the plaint is not true and it is not correct, that notice under Section 80 of the Code is not necessary, for that there is waiver of the right to get that notice. Stop. Stanza. Both the courts below have held in favor of the plaintiff on the question of right, title and interest in the property as claimed by him, and both of them have also held that the suit is not barred for want of requisite notice under Section 80 of the Code. Stop. This second appeal has been preferred by the defendants and the sole respondent is the plaintiff. Stop. Learned Advocate General, who appeared in support of his appeal in the first instance, strenuously argued that the suit was bad as having been filed before the expiry of 2 months from the date of service of notice under Section 80 of the Code. Stop. He also submitted that the decisions of the courts below, even on merits, were erroneous and fit to be interfered with in second appeal. Stop. We intimated that if we hold the suit to be bad on the ground of want of proper and adequate notice under Section 80 of the Code, we shall, has been done in several cases, direct the rejection of the plaint under Order 7, Rule 11 (D) of the Code, and shall not examine the property or legality of the decisions of the courts below as to the plaintiff title to the suit land and his claim for a decree for injunction. Stop. Since after having heard learned counsel for the parties, we are of the view that the first point urged on behalf of the plaintiffs has to succeed. We did not hear any argument on merits of the appeal. Stop.